another episode of Ask the Lawyer. This is the podcast where we tackle your legal questions no matter how big, small, or complicated they might be. As we always start, I am Evan Schwartz, the founder of the law firm Schwartz, Conroy, and Hack.
I'm Matt Conroy, Evan's partner.
And we always have to start with our little disclaimer, which I am going to read for you now. The information provided on this podcast is for entertainment purposes only and does not constitute legal advice. Watching this podcast does not create an attorney-client relationship with any of the attorneys featured or the firm. Please consult with a licensed attorney in your jurisdiction regarding any legal matter you may have. And with that, we're going to get right to our questions.
My wife wants a divorce. What should I do?
My wife wants a divorce. What should I do? Simple answer is go to a lawyer really quickly. And the reason why is because once that animosity starts in the house, you have kids, you own the house together, you're living in the same room. Somebody's tempted to move out. Somebody's tempted to take the kids. Somebody's tempted to clean out bank accounts. All of those things have an effect on the proceedings and can ultimately end up changing the course of the divorce. Getting good advice on what you can, can't, should, and should not do are pretty critical.
I agree. And it's a high tension moment, and self-help when you don't know what you're doing is probably not a good option for you. And we're not saying rush and go and get divorced. What we're saying is know your options, know what the consequences could be, know what the worst outcome is and what the best outcome is. And the best one to advise you on that is an experienced lawyer. If you don't know an experienced lawyer in divorce, then contact people that you know and trust who can maybe give you advice on how to get one of those.
And obviously, if you're in an unsafe position or you don't feel safe in your house, you should leave the house. You shouldn't stick to your guns. You could sort it out from afar. It's better to be sort of safe and able to look at your options rather than being in a sort of tense, dangerous position. Obviously, with divorces, we often see people in positions that are challenging.
Yeah, and when Matt's telling you, safety is your personal safety, that doesn't mean you need to move out. A lot of divorce lawyers advise their clients not to move out of the house. But if you're in physical danger or you have a threat to your personal safety and you need to exit for that, at least until you get the right advice, that's different than moving out.
In most states, if you're in a domestic dispute and you stay with your mother, you go to your friend's house, you go to the neighbors, that's probably not going to constitute abandonment. You're probably not relinquish your rights. But don't pack your bags, tell the kids I'm moving out, and then bolt. That has dramatic effects. But if you are not safe, if you don't feel safe, at least temporarily, little bag, not all your stuff, go to a safe place.
A mid-sized manufacturing company wins its claim in court after the insurer refused to pay for storm damage. The court finds the insurer acted in bad faith. What does that mean?
Acted in bad faith if a jury or a court made that factual determination could mean that the client doesn't just get the money for the damage that was suffered, but gets extra contractual damages. The idea of bad faith is that you get damages beyond what you were entitled to in the contract, and it is a creature of state law. And there are states that have no first-party bad faith, you versus your own insurance company, like New York. There are also states that have incredibly generous bad faith, like California. And, the two coasts are at the polar opposites of this. So if a court is making a finding or a jury is making a finding that the insurance company acted in bad faith, you must be in a state where that finding is going to mean you're going to get more money than what the damages were you actually suffered, just to get compensatory damages, as they say, for the losses, the property damage that the company suffered. So that's going to mean you're going to get maybe punitive damages, maybe attorney's fees, maybe treble damages, maybe double damages. Every state's different on what remedies are available to you, either under what we call common law, which is law that isn't governed by government regulation, meaning a statute or a regulation or a rule, but that it's just law that's developed in that state, or regulatory or statutory law where they specifically say, here's what you can get. Like Florida, for example, has a statute for bad faith, and it talks about what you can get if there's bad faith. Colorado has regulations that allow you to recover specific remedies if the claim is in Colorado. New York, as I said, you get nothing. California, you can get both common law and statutory bad faith, depending on the nature of the bad faith. So if there's a finding, then we're going to go to, okay, what am I getting besides the money I'm getting to fix my loss?
Does it make a difference whether you asserted a bad faith claim in that case?
100%. If you're the plaintiff, if you didn't bring a claim for bad faith, whether that's a separate claim in the complaint or whether that's just a remedy that you're entitled to as a result of the bad faith conduct of the insurance company, they ain't giving it to you. So if the court's making a finding that bad faith occurred, then the plaintiff who was harmed must have asserted a claim in their complaint that was sufficient to allow a jury or a judge to make that finding.
What constitutes bad faith?
Bad faith is usually a decision that's considered grossly unreasonable by the insurance company. Not just that it was a close call as to whether or not the claim was payable or not, but that there was absolutely no reasonable basis for the insurance company to deny the claim or not pay the amount they should have paid under the claim. That's a general rule. Each state's going to have a level or a threshold of how bad the insurance company has to have acted in order to get over to the threshold for a judge or a jury to find that it was in bad faith. But that's generally what it is. It's a gross disregard of the insured's interests.
Do you have any examples or hypotheticals?
Well, so where an insurance company knew that it was supposed to follow certain procedures in how they administer the claim, and they just ignored those procedures and then denied the claim. For example, they had an in-house adjuster value the damages instead of hiring someone with a level of expertise to go out and evaluate and value the loss. And they said, well, our in-house adjuster said that, your loss is really only worth $73,000 when it was actually $773,000. That's going to be considered a gross disregard of the insured's interest. You didn't properly investigate and administer the claim. Or, you could do something even more sinister where the insurance company has a profit motive to save money and does something, and you can specifically prove that they had a profit motive and it wasn't related to actually the value of the claim or whether the claim was payable or not. That's going to be another act of or an instance of bad faith.
What is the distinction in New York with first party versus third party bad faith?
So third party bad faith is where you as an insured get sued by someone else for either property damage or personal injury. You have a policy. The policy has a limit. So let's say the limit is $1 million for a property policy. And somebody slips and falls at your office. It's pretty clearly your fault. And they have multiple surgeries and they have like a $4 million case, right? And their lawyer says, hey, if you pay the policy, we'll take the $1 million. But if you don't, we're going to trial. The insurance company offers $100,000 and writes the case up and says, nah, we're not paying the $1 million. And the lawyer who's representing you that was hired by the insurance company to defend this case is telling the insurance company, this is a big exposure case. The insured has liability. If you don't pay, they're going to be exposed for a judgment in excess of how much insurance they have. That's third-party bad faith. The jury comes in with a $4 million verdict. The insurance company says, oops, sorry, here's the $1 million of the policy. And you, insured, are stuck with a $3 million judgment excess of what the policy provided. That's third-party bad faith.
And is that statutory or is that common law?
That is actually common law in New York. It's derived from a case, and it's interesting. It's kind of considered contractual exposure for the insurance company. It's a creature of a bad faith act under the contract. So even though it sounds like a tort, if you're thinking lawyer, tort versus contract, it's still really a creature of contract, but it's not written in any of the New York statutes. It's a case that was decided by New York's highest court, the New York Court of Appeals, where they created this remedy in New York. But that's not the same as you having your own claim against your insurance company that they didn't pay. You had a loss at your office, and there was $320,000 worth of damage due to a electrical surge or some kind of a leak in the building or something, and you go against your own insurance company and they don't pay, you don't have a bad faith remedy for that in New York.
Are there any punitive damages with the third party claims, or does it just speak to the exposure to the insured?
Um, Generally speaking, there is punitive damages, but it's a really high standard you have to get over in New York to get the verdict in excess of policy limits and then punitive damage on top of that. It's gonna have to be really, really bad conduct, almost to the point of criminal conduct for the insurance company to be exposed for punitive damages in excess of the excess verdict.
Two equal partners in a family owned business stop speaking to each other. One locks the other out of the company bank accounts, and the lawsuits start flying. We discussed this?
So,
Most disputes in small owned businesses they're like divorces. It's emotional, your partners, your work spouses, essentially. And the agreements that you have that govern what happens in the event there's a dispute, what happens when somebody dies, what happens when someone wants to be bought out. Those are all things that, without an agreement, it may or may not be covered by partnership law or LLC law or, whatever the vehicle of your business is in whatever state that you're in. You should know what your rights and obligations are, where you're operating. You get that from good corporate counsel intervention prior to there being a problem. But when someone gets locked out of a business and somebody gets shut off from an operating bank account, game on. The person who's being locked out, go get yourself a lawyer and go get yourself a TRO the next day. In New York, you have the option of going to commercial parts of the Supreme Court. You can go to federal court. The federal rules of civil procedure give you injunctive rights. You have rights under the CPLR to get injunctive rights. And by injunctive rights, I mean, to prohibit the partner from wasting the assets of the corporation or from keeping you from either accessing the property or from the money itself. But it's important, once somebody starts engaging in self-help, you have to enforce your rights, because once you're locked out, you get into sort of a pattern of conduct. It's harder to come back later. The sooner you do it, the better off you are.
right, now TRO is just another acronym for temporary restraining order, which is a form of injunction. And if you get a temporary restraining order, which is the thing you can do faster than anything else, that puts the other side, that's like check in chess. You've now pretty much stopped their bad behavior. But when you're in this acrimonious dispute, like a divorce, there's no good outcome if you fight all the way to the end. The best outcome is a mediated, negotiated resolution. Because if you're equal partners, no one's going to have the upper hand over the other in a really meaningful way, unless one of the partners has the power to open up down the street, take all the business because they have all the relationships or something like that. But beyond that, even there, you're going to have remedies as the partner that's been shut out. The best outcome of that is a negotiated resolution, just like the best outcome of a divorce is a negotiated resolution. But emotions get in the way. And, I've always said one of the reasons lawyers are busy, including our firm, is because one client thought the adversary was going to do something to them, so they decided to do something first. And that adversary wasn't actually doing that. But this sort of fear of she's going to take away my clients, or he's going to lock me out, or something's going to happen that the other side never even intended because they weren't communicating. And the next thing you know, it's World War III.
Yeah. In the real war, and divorce and partnership dissolutions are so incredibly similar.
Yes.
You're sitting at a precipice where it's over, right? The business is over as you know it. The marriage is over as you know it. And the question is, what are we going to do going forward? That's what the lawyer says. But the parties say, well, look what they did. They point backwards and say, I don't want to just split it 50-50. I don't just want to, I want to look back and say, he wasted this, she wasted that, he did this, he did that. And it's all the same. Corporate mismanagement, marital waste of assets, infidelity, sending
Right.
business opportunities to your friend down the road.
Emotions cause as much wreckage in a regular divorce as they do in a business divorce.
And you may have rights when it comes to all of those things. But the reality is that, you could fight. I mean, the War of the Roses is the best, right? Could have Danny DeVito here and tell us the story again. But, you could fight forever, right? Years. You see divorces that go on for 10, 12 years because they can't.
Don't remind me.
But it's not let go of the present. You can't let go of the past. So with businesses, what's the purpose of a business? It's a for-profit business most of the time, right? So how do you get yourself back on your feet? Do what you can, you got to just end it. Throwing good money after bad, it's what makes partnership disputes go around.
And it's what makes lawyers money when they really shouldn't be making that money, but the clients continue to drive that litigation engine. And I've said this before, but I've had clients who call me up in the middle of this dispute and they'll say, I don't care what it costs. I'm going to do X, Y, and Z. And by the fourth bill, they care what it costs.
Yeah.
Or I've said to them, when they're taking emotionally based action or directing the firm to do emotionally based things, I will say things to them like, all right, if you want to litigate, I've got a lot of college bills, I have a lot of home expenses, and I'm happy to help you pay for those. So let's just keep going. And sometimes they'll pause and go, wait a minute.
The other dynamic you see is the partner who wants to prove that they were right, and the spouse who wants to prove that they were right. I told you he was a bad guy. I told you she was cheating on me. I told you he wasn't doing what he was supposed to do. And you could litigate for years trying to prove that you're right.
And people do.
They do. But good mediators can identify that trait almost right away, and you bring them in. You bring those people in. You give them a mediation session so they feel like they went to court and they express their opinion, and then you can formulate a settlement where you make that person feel like they won. That's how you deal with a really difficult person who wants to be right.
Yep.
I own a marketing agency and I just sued a client for unpaid invoices. The client just sued me back, claiming poor performance and reputational damage. So what now, and how can I prevent this in the future?
So if I'm a lawyer and a client comes to me with this question, I would hope they come to me before they file the lawsuit, because these are the types of defenses and claims that come up when you sue for money. And you have to know what it's going to cost to litigate, anticipate the fact that those claims are going to be coming, and figure out what the value proposition is in bringing this lawsuit, right? Now, if you've never heard from the vendor, right, you're suing for unpaid invoices and they've never complained or said anything, and you've sent them multiple bills and they didn't respond or they're just not paying you, you might have certain claims under certain states' law. Like there's a cause of action in New York, it's called account stated. And it means basically you don't have any defenses. I've sent you these invoices multiple times. You never objected to the services. You have to pay for them. And that's a pretty powerful claim. But if this was gonna happen out of the box, and you've already gotten complaints and you knew this was gonna be a back and forth, you should be thinking about the strategy around and the cost around what's gonna be involved in litigating this case.
And the way this question's posed, with a in the operation of your business, when you have one customer who's not paying an invoice, this isn't a legal response, but as a matter of business practicality, the benefit to you of trying to chase that money versus the potential legal expense, reputation, aggravation, and potentially having a former customer out there just smearing you all over the internet for the next 10 years. Those are business decisions that you have to weigh. And, so if you got a $2,000 bill and it's going to cost you $10,000 of pain and somebody out there bad-mouthing you all over, Reddit, uh, you might want to think long and hard before you just start suing people.
Right, and then there's a question of what is your relationship with the vendor contractually? Do you have a right to get collection costs? Can you get attorney's fees and expenses if you're successful in pursuing the claim? Did you agree to that? Is that on your invoices? Is this it's services, so it may not be goods, so it's probably not governed by the Uniform Commercial Code because it's services. So then it's going to depend on what was in your agreement. If you had an agreement, if you didn't have an agreement, you're going to have to pay your own attorney's fees. So there's a lot of components to figuring out what to do before you bring that action. And if they make that counterclaim, you're going to need somebody to assess the merits of that counterclaim, what it's going to cost to defend it, and whether it's worth it for you to pursue this, or if you're looking for an early exit and a quick settlement.
And that's just cost benefit analysis. And, as a CFO or CEO, you should be doing that all the time in what you do.
Agreed. Funny, I'll use this in legal malpractice. Lawyers who sue clients for fees will often get the defense of you committed legal malpractice, whether it has merit or not. It's used as a lever to avoid paying legal fees. And over the years, insurance companies got wise to the fact that this happens, and basically they exclude it from their policies now. So if you get a counterclaim for legal malpractice as a defense to a lawsuit for fees, it's not generally covered, right? And so you need to be very thoughtful as a lawyer when you're thinking about going after a client, how you're going to do it and how you're going to go about it, because the policy is not going to help you out when that counterclaim comes in.
And look, if you're in New York or states that have fee, alternative dispute resolution for legal fee disputes, which we have in New York, you can include that in your retainer agreements, and that is sort of the JV version of having to go out and sue the client. Threatening to bring a mediation or an arbitration at the fee dispute stage sits a little better with the client. We've had success doing that without the client necessarily going sort of thermonuclear on us.
Exactly.
So do I need a will? And if I do, why do I need a will?
That.
So the short answer is you don't have to have a will. There's no legal requirement that people have wills. The reason you have them is to avoid having to go into court under what's called an administration. If someone dies without a will, they refer to that as intestacy, that you died intestate, meaning without having expressed your wishes for the disposition of your estate property. When that happens, whatever state you died in governs the disposition of that property. If you're in New York, the wife gets 50%, the children get 50%. If there is no wife, the children split it equally. If there's no wife and there's no children, it then sequentially goes down to people related to you, sort of like degree by degree. Oftentimes people don't wish their property to be disposed of that way. They want all their property to go to the surviving spouse, or they want their property to go to the ASPCA, or they want to cut out, a sibling that they haven't talked to in, 50 years. There's a lot of reasons why you wouldn't want your property, the disposition of your property, to be decided by what New York state law says. You will decide it yourself.
Right. And I don't know if I believe every state has a law on the books that says what happens to your property if you die without a will. I'm not sure it's every state,
I believe.
but every state I've ever looked at has a method of how your assets will pass if you die without a will. But there's a lot of other questions that would be asked by a lawyer who handles those types of things as to why you would need a will, not just controlling where your property goes, but do you have children? Are they underage children? Do you have people in your family with special needs that you want to provide for? Are there specific situations that you need to deal with or want to deal with to make sure that not just your property is taken care of, but people in your life are taken care of? You know, if you die and your children are underage, they're going to need a guardian. And maybe you have a spouse. Maybe you don't. Maybe you want to have a plan for what if both of you die at the same time? There's a whole lot of questions as to whether or not you should have a will, or what lawyers in that space will call an estate plan. A plan for what's going to happen to the people around you, what's going to happen to your property, and what's going to happen to you if if you pass. Now, you don't necessarily have total control over what's going to happen to you when you die. You could express your wishes. They're not usually directives that are truly enforceable by like a court. You know, do I want to be cremated? Do I want to be buried? Do I want to, those types of things. But there's also things about what happens if you get sick and you can't make your own healthcare decisions. So besides wills, even if it's not a question of whether you want a will, well, do you want someone making healthcare decisions for you when you're not making them? So then you need a healthcare proxy. Do you want decisions about end of life to be made by someone other than you, or do you want those directives to be made in something called a living will? So there's a number of different things that you would need to have in the event that you are becoming extremely ill or on the verge of dying, or when you do die. And so there are questions to be asked, not just, do I need a will and why? It usually leads to what lawyers always say, oh, you have some questions? Well, we have some questions before we can answer your questions.
Yeah. And I think the good point there was that a will is just a piece of a bigger estate plan. And it really is sort of the principal document. But, you know, dealing with family situations, getting a healthcare proxy, appointing who you would like to be the guardian of the children, even though that's not necessarily guaranteed that it'll happen, do not resuscitate orders, living wills, things like this. Those are all little pieces of estate plans that, are helpful. And ultimately, the purpose of these documents is to express your voice as to what you wish when you're not able to do it yourself, either because you're deceased or because you're incapacitated.
One of the things I will say that regardless of the nature of your estate plan, if you have important original documents, like a will, which there still needs to be an original in this world where most things you don't need originals anymore, but don't take all your original things and stick them in a safe deposit box. Because when you die, no one can get to your safe deposit box. So don't do that. Find someone you trust to entrust those originals to, preferably a lawyer, but perhaps someone else, because if you are to pass, now everything that somebody needs to do what needs to be done for you and your family after you're gone, they can't do because they can't get in your safe deposit box.
On the same subject, if you are in a position where you're executing wills, and either yourself through AI or the internet, or a lawyer who might not do this for a regular as a regular practice, had you executing multiple copies of the wills, do not do that. Do not make original duplicates or triplicates of the will, because you will need all of them in order to properly probate them in New York. It's not that you can put one will in. If there were 3 originals, you have to probate all 3. And the reason why is because if you can't find one of the 3, there's a view of this that you destroyed it, and that's an act of revoking the will. So when you do your will, one will, not 2, not 3, not more. If a lawyer says we're going to do 2, you're going to keep 1, I'm going to keep 1, say respectfully, can we get a second opinion on that?
I actually had that happen with a family member who was in a bad marriage, and her husband decided he was going to self-help in wills. So he typed them on a typewriter, and he typed multiple original wills. and then had them all executed. And no one could tell which one was the last one he prepared because each one says it revokes all prior wills. So they couldn't get the will admitted to probate because he had typed up multiple original wills and he kind of, in his plan to disinherit his not at that time ex-wife, he prevented the disinheritance. So
My first trial in New York was a circuit court trial in Queens, and I represented the son of a woman who passed away with 3 children. One lived in Cooperstown, one lived in Queens, one lived in Florida. And when the woman executed her will, she executed 4 copies, one for the lawyer and then one for each of the kids.
so 4 originals.
4 originals. Now, I'm sorry, one for the testator and then one for each of the children. And
The testator being the maker of the will.
the maker of the will. The woman passes away. My client tries to admit the will to probate in Queens Surrogates, and the brother upstate objects to it, saying, my mother revoked the will in front of me. She told me she didn't want this. And by the way, the will cut out the upstate brother from inheriting the property, left some property to the daughter in Florida, but gave the bulk of the estate to the son in Queens. The upstate son says, the mother revoked the will in front of me, and she took it, she ripped it up, and she threw it into the fireplace while the fire was on. So we, in the course of discovery, deposed the lawyer, the sister, both brothers to try to figure out what happened. Like, can we account for all 4 wills? We only had 3 of the wills. So on the face of it, it's conceivable that what he's saying is true. There were 2 interesting things that came out of this, which is somewhat far afield of the question, but interesting nonetheless.
Keep going far afield. I'm entertained.
The dead man statute in New York says that the words of the dead man are inadmissible when they're being offered by someone who benefits from that person's death and from those words. And so this case fit perfectly into the dead man.
She ripped up the will, so now I get everything. She did it. I saw it.
Exactly. So this came in the form of an eliminating motion just prior to trial, that the mother's words were inadmissible because of the dead man statute. The court let in the allegations that she ripped it up, and there was what I thought was a good argument that the act of ripping it up is in fact a statement. And so he said, it's a conducted statement. We're not sure. I'll let it in for now, and we'll see what happens. But the lawyer says, when we executed the will, I gave one to the testator, and then I mailed the other 3 to the children. My client says I got mine. Upstate says I got mine. The daughter in Florida says I never got mine. So simple math wins the case. So the court ultimately found that there were 4 wills, 1 was lost, 3 were submitted to probate. There's no, that evidence is stronger than the cutout son's position that the will had been revoked. So we won basically on a bench verdict from the surrogate.
So a curveball, you lose, and the money all goes to the brother who claims the will was ripped up and revoked. Did the lawyer commit malpractice as supervising the execution of multiple versions of the will?
So the short answer is no. And the reason why is, in the event that we lost, losing would have meant that the property in the estate would have been split 3 ways instead of basically 80% going to my client. But assuming that we lost, the question of whether or not the 4 will paradigm constitutes malpractice, it almost certainly doesn't. Executing 4 wills might deviate from the standard of care of estate lawyers in New York, but the act of executing 4 wills was not the cause of my client's loss. My client's loss was based exclusively on the fact that his mother revoked the will. The fact that there were
Right.
4 of them
Got it.
didn't cause the loss.
That didn't go.
So even
The multiple executions was not the reason for the
there may
problem.
have been malpractice, but the deviation from the ordinary standard of care by that lawyer didn't cause the client's damages.
So if if none of the original wills had ever been admitted to probate because we couldn't figure out what the last one was, that might have been a malpractice that caused the loss.
Yeah.
But that didn't happen in your case.
Exactly.
Got
And
it.
his damages would have been the difference between 80% and 33%.
Got it.
Directly attributable to the deviation is what? Executing
Multiple wills.
multiple wills
When you don't know which one's the original.
because there's a strong possibility that someone is not going to be able to find all 4, in which case the expressed wishes of the testator never get before the court.
Yep.
And that the fear, right? The likelihood of that happening or that's what actually ends up happening. And so that's a direct causal link between the deviation from the standard of care and the plaintiff's damages.
Got it.
I just got into a car accident and I'm at the scene. What should I do?
All right. This is one of those common problems that happen to people all the time. Unfortunately, many more times than we wish would occur. But the first thing you need to do is make sure that you're safe to move and that you're not badly injured, because in the initial contact, there's a trauma. And people didn't even realize that they could be pretty badly injured. Assuming that you feel comfortable that you can move, you then wanted to call the police immediately. Call the police, report the accident in your location, and get them to the scene. The next thing you're going to do is, if you can exit the car safely, then you want to make sure that everybody's okay and that somebody doesn't need immediate medical attention of some kind. Once you get past those preliminaries of personal safety for you and those involved in the accident, then you can start getting into the things that you should do, like take photographs of the event and don't move the vehicles to, I got to move the car out of the way because, there might be oncoming traffic. Well, generally speaking, unless you're on a really busy highway where you could get run over, that's not a great move. It's better a move to just leave things the way they are and take your own photographs. Also, perhaps get the information from the other driver, their insurance card, their license plate, and take photos. Those are the things that I would say are the most immediate things to do, and wait for the police to come. But I'm going to throw a curveball into it and say ask Matt, okay, you're in a car accident, all those other things have occurred, but you know that you've been drinking all afternoon. What do you do?
That's a tough one. So the police are going to come. If you're operating the vehicle intoxicated, you probably won't have coverage for that accident. I wouldn't make any statements to the police. I wouldn't indicate to anybody whether I was the driver or not the driver of the vehicle. Depending on what county I'm in, if I'm in Nassau or Suffolk or Westchester, you really shouldn't move the cars. But if you're on a parkway or a highway within the 5 boroughs, you have to move the cars as long as there isn't serious bodily injury or serious.
Right, which is what I was saying. If it's if leaving the cars where they are is unsafe, but because you're in New York on the Belt Parkway, that is different.
In the city, the rule is that you have to move the cars over the shoulder if it's safe to do so. In Nassau, Suffolk, and Westchester, and New Jersey, you should not do that. So, weighing the trouble that comes from a small damage, no injury insurance claim versus a potential operating under the influence, driving under the influence charge from the police, it's virtually impossible to think that you are going to be able to make those decisions in real time when you've been drinking all afternoon. So the best thing you should probably do at that point is call somebody and have them come to the scene.
Lawyer on speed dial would be good.
Maybe lawyer, maybe friend, but at a minimum, have somebody come to get you. And then probably talk to a lawyer who specializes in drunk driving and try to make the best of it.
It's an awkward situation because you're dealing with a situation where you want to do the right thing because you've been in an accident, but at the same time, you have a criminal exposure potentially and all types of other exposure because you've been driving while under the influence. And maybe the accident wasn't 100% not your fault. You're driving and you've been drinking all day and somebody rear ends you. You still have a lot of risk that you have to deal with because you were driving a car under the influence of drugs or alcohol.
But that is going to make a mess of the insurance claims, regardless of the causation element to it, and adding on a police interrogation and being locked up for drunk driving and refusing a breathalyzer and all the things that follow from that difficult day for that gentleman.
Correct.
Thank you for joining us. Hope to see you on the next one, which will be coming very soon. And just a reminder on the disclaimer one more time. The information provided on this podcast is for entertainment purposes only and does not constitute legal advice. Please consult with a licensed attorney in your jurisdiction regarding any legal matter you may have. Watching this podcast does not establish an attorney-client relationship with any of the attorneys featured. Take care, everybody.